intrigued, and you have missed. Yes, we've had two guests, we've discussed two issues. We looked at the fuel crisis and the Naira crisis. So, and this is our third guest platform, where we'll also be discussing a very important issue. We'll be going to the legal and political way this time around. Kayode, what's
our guest on the program today, Supreme Court ruling on Senate President Lawal and Akpabio. Now, our guest for this topic is a renowned legal practitioner, Mr. Oni Alabi. He's the former chairman of Nigerian Bar Association, Oshobu branch. He's also a former national officer of Nigerian Bar Association and also a university lecturer. Barrister Oni Alabi.
You're welcome to the program, sir.
Thank you for having me here. And I say good morning to our viewers.
Thank you very much, sir. Now, let's look at the issues surrounding the crisis, the challenges that the Senate President had that led to the Supreme Court judgment. What exactly do you think that it should have happened in the first place?
Well, the point is, I can just summarize it in this way.
Okay.
Is the question of politics and law on a collision course.
Okay.
It was politics that led to the institution of the action.
Yes.
The two of them, Mechina, Lawal, they are playing politics. We must understand something from the onset, that the principles in politics are different from the principles in law.
Okay.
In politics, all over the ages and anywhere, an average politician may desire, can strive to get anything either by hook or by crook.
Right.
The major and the fundamental interest is getting the power.
Yes.
So that he can exercise such power over the people. He does not care how it comes about that power. So that's why there will be political strategies, political gimmicks, this and that. That was what the two of them were doing. So, and when it happened that the INEC said Lawal is now the senatorial candidate, Mechina decided to go to court because he felt he was the one that had been elected. And that is the end of politics. Now, once the issues are submitted to the court, it now becomes issues of law. And before you go to court, you must have facts. In the legal profession, we say law usually is 9/10 of fact. Say in administration of justice, if we give as an example that everything we need to administer justice is 10 in number, 9 of those things will be issues of fact. The remaining one will be law. So it is those facts who apply the appropriate law. What happened in this case is the issue of the manner of approach. Yes, we have the court system, but you cannot just blow in on any court. There are procedures, there are processes, and there are different ways, procedures, processes for different grievances. One of the general way of approaching from the Superior Court of Record, which is High Court, is what we call writ of summons. So, generally, you go to court, you state your fact, this and that, but for some grievances, there are some other different procedural rules or processes different from writ of summons, and that is what is called originating summons. Originating summons was the process employed by Mechina. And what do you use originating summons for? You use originating summons for only issues of law, devoid of conflict of fact. You use it for the interpretation of a statute. Maybe you say Section 6 of the 1999 Constitution, what is its import? If you want to do that before a court, you go by originating summons. And you do it by what we call affidavit. Affidavit is a means of stating your fact that you state on oath. You have to go before the commissioner for oath. It's an oath. Now, if somebody wants to react to that oath, he or she will also react by a form of affidavit.
Okay.
In this case, we call it counter affidavit. The meaning is just the affidavit you are filing to oppose the earlier affidavit.
Okay.
Once you have conflicting affidavits, that situation translates to conflict of fact. Your case is completely out of originating summons because they are disputed. Now, in this case of Mechina, part of his case, the fact that he submitted before the Federal High Court, were full of allegations of fraud. In law, there are different standards of proof. In civil case, the standard of proof is what we call on the balance of probability. If the two of you are litigants in court, in civil proceedings, maybe you are fighting over a piece of land, your case will be determined on the balance of probability. And that's why I would say the court will put the pieces of evidence on both sides on an imaginary scale. And will now see which one is weightier than the other. That one whose own is weightier will get the judgment. Then it means your evidence is stronger than that of your opponent. That is in civil case. In criminal case, like somebody is charged for murder, for stealing this and that, the standard is what we call proof beyond reasonable doubt. That is, you are the one who is going to establish the crime against the person you have accused, not the person. The person doesn't need to participate in it. You have to bring the evidence before the court. That one is higher than proof on the balance of probability. It's a higher standard. Now, and if you raise, like Mechina did in his case, if you raise an issue of crime in a civil case, that issue must be determined beyond reasonable doubt. The court will no longer apply the standard of a civil case. It has to apply the standard of a criminal case to determine that crime. Now, when you have raised an issue of crime on oath, and somebody against whom you have raised it have to oppose it, the affidavit, the oath are in conflict. That takes your case away from originating summons. It's a problem between him and his lawyer for the wrong choice of method of approach to the court. So, but it's unfortunate that even eminent lawyers have commented on it. They have not been able to analyze it the way I briefly said it. So they've been blaming the Supreme Court. It is unfortunate because as lawyers, even if we are in politics, when we are to state the law, we state the law clearly. And not allow ourselves to be beclouded by any political emotions. So it's wrong. So even those who are not lawyers, the members of the public, I want to appeal to them. When the court delivers a judgment, don't rush and begin to condemn. Because you have not seen the judgment. The only evidence that a court, I accepted your invitation to come and talk because I've read that judgment. Therefore, I can speak authoritatively. That's where I got the information. I was not part of it, but it's what I read in the judgment of the Supreme Court. That's what happened. In fact, there are so many other factors that will have worked against Mechina that the Supreme Court did not go into. So, because it will amount to wasting the precious judicial time to be going to that when they can settle the case at a threshold. Once they find out that the procedure you employed was wrong, we can't listen to you. That's why the case was struck out. So the summary is that both the Federal High Court and the Court of Appeal that delivered judgment in his favor earlier, they were wrong. It is the Supreme Court that is right. And the Supreme Court is right because it has decided according to law. And like I said earlier, whenever there is a collision caused between politics and law, politics will have to lie prostrate, while law will stand triumphant. So that's what has happened in this case. But there are, emotions have gone rife. While we have to give these people the benefit of the doubt is that judges or justices of the Supreme Court cannot talk back to the public. You just continue to condemn them. They can't talk back to you. So we should bear that one in mind. Even if you are not a lawyer, before you begin to comment on public place, consult your lawyers. That what is the implication of what has happened. So there was no question of merit. They didn't consider merit because the procedure was wrong. So if you don't invoke the jurisdiction and the power of the court by the proper procedure, the court will not listen to you, no matter how good your case is. So that is what happened. So they didn't go into the merit of the case, whether this right, because they shouldn't have employed originating summons, which is usually used for interpretation of statute or the provisions of law, where facts are not in dispute. So that's the case.
All right. Now, you have explained clearly now, and we seem understand better now. But in the case of members of the public, this is not the only judgment that has elicited controversy by members of the public, and this seems to be impacting negatively on judiciary. What do you think that the judiciary can do in order to let people have clearer picture of their rulings?
You see what my comments so far do not mean that in every case the court is always right. That's not what I'm saying.
Okay.
There might be cases, situations where the court will be wrong. And then, different factors will come into play. We have identified the issue here, wrong procedure. There might be cases, if the case had gone into full-scale hearing, the court will have had the benefit of commenting on different documents that they presented before the court. Oh, this one shouldn't have been there. This one should have come before this and that. You know, there are conflicts. No, we have to, I think I have alluded to that. Number one, let us not, as members of the public, don't let us rush to condemn the judgment of the court if we have not read it, if we have not had the understanding by those who are trained to interpret it to us. I am not saying either that all judges are saints, because they are members of the society. As the society is full of different kinds of people. It's not limited to the judges, it's not limited to lawyers, it's not limited to the judiciary. You have them in all sectors of the economy. So what we will be doing, the judiciary cannot do more than that. Like I said, these people, they have been condemned. Have you had any reaction from them? They must not be heard to be talking to the public. They can only talk to us through their judgment. And so those who the only thing is that before you appoint people to become judges, you watch character, you watch learning. What is the depth of the knowledge of that person? All those things play significant roles, because you cannot give what you do not have. And judges are recruited from amongst us, from those who have been trained as lawyers. But we are in categories. We are in categories. The only thing, part of what the judiciary will do is that to ensure that appointment of judges and justices are based on merits and merit only. That we do not allow politics, ethnicity, and such extraneous matters to come into play before we put people on the seat of judgment. Because once you have placed them there, they are like representative of God. What they say, it is not their persons, it is the institutions that they represent. So whenever they talk, that will be the law. When the High Court speaks, it is the law until it is set aside by the Court of Appeal. When the Court of Appeal did its own, it remained the law until the Supreme Court that has the final say. So as far as the case of Michina and Lawal is concerned, the Supreme Court has spoken, and that is the end.
All right. Thank you so much, sir. And the election is just a few days away. And apart from the case of Lawal, Senator Akpabio too had his own case.
Yes, I think they are similar.
Yes, they're similar. Recently, there was a governorship aspirant to candidate, actually, that was also, removed by the court.
Yes.
These things are coming a few days to election, when INEC has actually told us that everything is ready. Now, let's look at the implication of this.
Yes. Election issues are time-bound.
Okay.
They are not like all other cases.
Okay.
You may be surprised. There are some cases that have spent 10, 15 years in court, undecided. But we don't, by the rules that we have set for ourselves, we don't allow election matters just to go on like that. Okay. So they are time bound. Okay. So if people don't forget, I said this is politics and law on a collision course. And politicians will do their own things their own way. Most of the time, more often than not, to be in conflict with the law. So it is only at the time the case comes before the court that the court will make a pronouncement. Whether the election is tomorrow, the court will not care about it. That is when it comes. Let me give you an example. In 1992, when I was Osun State Legal Advisor of the defunct Social Democratic Party, some of our party members, they did the primaries in Ijesha land. And it was disputed. So they came to me as the legal advisor for the opinion. I told the other man that yes, from what you have said, something got wrong. But my advice as the legal advisor is that you go back, we come and repeat that primary. And so I will come and monitor it. The man said no. He wanted me to declare him. I said I will not do that because I was not convinced. That is politics. So if I had given him, that is politics. That is not law. But I knew I owed a duty to my primary constituency. So when I didn't do that, he went to court. Now the court decided. The day the court decided, we were to go to election the following day. And the court made another today that another person should be substituted. So all other people in the party that are not lawyers, they were panicking. I said, wait. I got the judgment of the court, sent it by courier to the national office because apart from our level, the national office will have to comment on this. We have complied with the judgment of the court. And we went to election the following day with the other candidate. So eventually the case traveled up to the Court of Appeal where they confirmed my opinion. The man is late. God bless his soul. He came back to apologize. I said, you don't. I was a lawyer. You are not. So you are playing politics. But the fact that I was in politics does not mean I will jeopardize my primary constituency. So that's the way it works. So it will continue to be like that once the politicians decide not to play their games according to the rules. So there's no way you can afford all those things. You will continue to have it. Because they are the one fighting it. And you don't get, power is not served a la carte. You fight for power, you wrestle for power. So at the end of the day, whoever wins, they will know, yes, I have tried. This is the one who wins. That man will continue.
Ẹ ṣé amòfin Awoniyi Alabi, ẹ ti bá wa yanjú gbogbo ẹ̀ ní èdè òyìnbó. Ẹ wá já wò ní èdè abínibí wa kó lè bá yé àwọn ènìyàn wa tí wọ́n wà níbí. Tá a bá wo ìdájọ́ ilé ẹjọ́ tó ga jùlọ lórílẹ̀-èdè pàápàá jùlọ lórí ọ̀rọ̀ Senate President Ahmad Lawan àti Machina. Ọ̀tọ̀ níbi tára àdúrò kọ́ ọ̀rọ̀ ó wò sí, ọ̀tọ̀ níbi tó wò sí. Ojú ò lẹ́yìn fi wò gẹ́gẹ́ bí amòfin.
Ẹ ṣé kéèyàn tó lọ ilé ẹjọ́, Yorùbá ní ẹjọ́ làákọ́ àìkọjá. Ẹni tó bá lẹ́jọ́ tí ó rò ni ó lọ ilé ẹjọ́. Ẹjọ́ tí ó rò kì í ṣe òfin. Ṣùgbọ́n ẹjọ́ tí ó rò yẹn àgbékalẹ̀ òfin wa lórílẹ̀-èdè kò sí tó fẹ́ ṣẹlẹ̀ síyàn tí àwọn àgbékalẹ̀ òfin wa ò ti ní tán lóògùn rẹ̀. Gbà téèyàn bá rojọ́ rẹ̀, àwọn agbẹjọ́rò àtàdájọ́ wọ́n wá wo òfin tó bá ẹjọ́ rẹ̀ yẹn mu. Òfin yẹn ni wọ́n wá mú ni wọ́n wá lò fún. Téèyàn bá sì fẹ́ lọ ilé ẹjọ́, kì í ṣe sẹ́mọ̀ pé èèyàn ò lè jí láàárọ̀ kó kàn lọ sí ilé ẹjọ́ kó kànlẹ̀kùn ilé ẹjọ́ pé ẹnìkan wá sílé mi lánàá wọ́n wá iṣu lóko mi adájọ́ mo fẹ́ rí ọ kì í ṣe báwọn ṣe ń ṣe wọ́n á kọ̀wé wọ́n á gbé lọ ilé ẹjọ́ wọ́n á fòǹtẹ̀ ilé ẹjọ́ lù ó ní àwọn òfin tó là kalẹ̀ ọ̀nà téèyàn gbọ́dọ̀ gbà láti wá béèrè nǹkan lọ́wọ́ ilé ẹjọ́ kì í ṣe ọ̀nà kan náà ènìyàn lè gbà ẹ rí i pé níbi tí ọ̀rọ̀ ẹlẹ́lẹ́kṣọ̀n ìbò tán bá lọ ilé ẹjọ́ wọ́n lò ti fáìlì petition wọ́n yẹ pé lórúkọ mi tán bá pè lórúkọ mi ilé ẹjọ́ jù sígbó torí tí òfin ní kí wọ́n lọ. àwọn ọ̀nà míì tún wà ọ̀nà tó àwọn lò níbi tí mẹ̀chínà ọ̀nà tá à ń pè ní originating summons ìkan lára àwọn ọ̀nà tá à ń gbà lọ béèrè ẹ̀tọ́ wa lọ́wọ́ ilé ẹjọ́ ni ṣùgbọ́n kí là ń lo originating summons fún ní tá à ń lò fún ni pé tó bá jẹ́ pé ẹ̀yin méjì tá a jọ ń sọ̀rọ̀ yìí tí ẹ bá ní èdè àìyedè láàrin ara yín tó jẹ́ pé tí ẹnìkan bá sọ̀rọ̀ ẹnìkejì ó takò irú yẹn wọn kì í lo originating summons fún ṣùgbọ́n ibi tó bá yẹ pé ọ̀rọ̀ wa papọ̀ bóyá ẹsẹ̀ òfin kan la pẹ́ kí ilé ẹjọ́ bá wa tú tàbí ẹsẹ̀ constitution orílẹ̀-èdè Nàìjíríà la fẹ́ ìwọlé ẹjọ́ kí ni túmọ̀ kí ni irú yẹn ni wọ́n ń lo originating summons fún ní tó bá ti lédè àìyedè nínú wọn kì í lo originating summons fún
òun ni màṣínà wa lò
òun ni màṣínà lò Supreme Court ò lẹ́bi òfin ni wọ́n lò òfin orílẹ̀-èdè Nàìjíríà tó sọ pé tó o bá fẹ́ béèrè nǹkan lọ́wọ́ wa irú ọ̀nà báyìí ni kò gbà ó sì gba ọ̀nà yẹn nípa àdé yìí àtẹ̀lé gbọ́ ẹ rí i pé wọ́n lọ síbi pé ẹnìkan ló kọ́kọ́ ṣe election ni ẹnìkan yóò ṣe ní nǹkan kan tí wọ́n ó bá lọ síbẹ̀ yẹn wọ́n ń fàsìkò ilé ẹjọ́ ṣòfò ni ilé ẹjọ́ sì ń fàsìkò ẹ̀ ṣòfò òní wọn nígbà tó ti wá rí i pé tí a bá ti ṣèdájọ́ lórí eléyìí àwọn nǹkan yòókù tó kù ìrégbè ni.
àwọn kóòtù tó wá kọ́kọ́ dájọ́.
àwọn kóòtù tó kọ́kọ́ dájọ́ ni wọn ò dájọ́ dáadáa àwọn yẹn àti ilé ẹjọ́ àkọ́kọ́ àti ilé ẹjọ́ ìkejì àwọn ò dájọ́ yẹn pẹ̀lú òfin orílẹ̀-èdè wa Supreme Court ló ṣẹ̀ wá dájọ́ adúpẹ́ lọ́dọ̀ Ọlọ́run pé Supreme Court nígbà tó débẹ̀ ìdí náà nìyẹn tí a fi ní ilé ẹjọ́ nípele kì í ṣe kó déédéé wà bẹ́ẹ̀ lásán torí pé a rò pé àwọn tó wà ń bì bóyá ọgbọ́n wọn yàtọ̀ tó bá tún lọ sókè ẹ rí i pé ọdún tí èèyàn fi ń di adájọ́ High Court ó kéré sí ti Court of Appeal ti Court of Appeal ó kéré sí ti Supreme Court òfin náà wò pé bó bá ṣe ń pẹ́ níbẹ̀ náà ni ọgbọ́n á máa pọ̀ sí ọgbọ́n yẹn á máa dàgbà sí òun la fi ní ilé ẹjọ́ nípele àwọn méjì tó kọ́kọ́ dájọ́ wọn àdájọ́ rí ìdájọ́ tí Supreme Court ṣẹ̀ṣẹ̀ gbé kalẹ̀ òun ni ìdájọ́ òdodo mo sì fẹ́ fi àsìkò èrò àwọn èèyàn wa tí àbámọ̀ nǹkan nípa àdájọ́ ká má máa sọ̀rọ̀ lórí ẹ̀ ẹ pè mí mo wá ń sọ̀rọ̀ lórí ìdájọ́ yìí nítorí pé mo ti rí ìdájọ́ mo ti kà á mo mọ ohun tó ṣẹlẹ̀ tí ilé ẹjọ́ fi dá ohun tó dá kò sí tó kan ilé ẹjọ́ pé níta ẹjọ́ ń ṣe níta ní tó bá wà nínú òwe níwájú ilé ẹjọ́ ilé ẹjọ́ ṣèdájọ́ lé lórí tá a bá fira wa náà sípò àwọn pè bẹ́ẹ̀ ló yẹ kó rí tó bá já wà lẹ́jọ́ tá a ti gbé kankan wájú ilé ẹjọ́ tí ilé ẹjọ́ wa sọ pé ebi lánàá kíní kan ṣẹlẹ̀ bó o láti rí àdúrà rẹ̀ pé akílọ̀kan ilé ẹjọ́ níta bá gbé síwájú ilé ẹjọ́ ìní ilé ẹjọ́ ó dá ìní ilé ẹjọ́ ó dá ó ṣe ní láàánú pé àwọn agbẹjọ́rò kan gan náà ti sọ̀rọ̀ eléyìí tí ò bófin mu tí ò dẹ̀ bá iṣẹ́ agbẹjọ́rò mu tí a lè torí òṣèlú bóyá ìhà tá a kọ sí olóṣèlú kan káwa máa fọwọ́ fẹ̀kọ́taná fún aráàlú kò dáa tó bá yẹ ká sọ̀rọ̀ bí agbẹjọ́rò ká sọ̀rọ̀ bí agbẹjọ́rò tá a bá fẹ́ sòṣèlú ká mọ̀ kó ṣèlú láṣẹ ẹ̀rí pa pé àwọn òfin tó tẹ̀lé òṣèlú àti ẹjọ́ agbẹjọ́rò àti ẹjọ́ ìdájọ́ wọn yàtọ̀ síra wọn olóṣèlú gbogbo ọ̀nà ló lè gbà láti fi rí ní tí bá ń fẹ́ lábẹ́ òfin ti sọ ọ̀nà tó lè gbà ọ́ tó o bá fọ̀ náà lẹ̀ tó gbọ̀nà ní kò ní rí tó fẹ́.
ẹ wá jẹ́ ká wò báyìí ọ̀pọ̀lọpọ̀ ọgbà ló jẹ́ pé tílé ẹjọ́ bá tí wọ́n bá gbé ìdájọ́ wọn kalẹ̀ ọ̀tọ̀ ni bí ó sì rí lára àwọn aráàlú olúkálùkù wa máa sọ̀rọ̀ àlùfànṣá lóyìí pé yìí sí àwọn adájọ́ nǹkan kan ọ̀nà wo lẹ rò pé ilé ẹjọ́ gan lè gbà láti máa mú kí àgbékalẹ̀ ìdájọ́ wọn kó máa yé àwọn aráàlú yékéyéké lójú náà àti má jẹ́ kí iyì wọn kó máa wọlẹ̀ lójú àwọn aráàlú.
ẹ jẹ́ kí n kọ́kọ́ bẹ̀rẹ̀ báyìí mo fẹ́ kí gbogbo wa mọ̀ gbogbo aráàlú ká mọ̀ pé táyàn méjì mẹ́ta bá lọ ilé ẹjọ́ ẹnìkan ni ó jàre ẹnìkan ni ó jẹ̀bi ó dá lórí ẹjọ́ tí olúkálukú bá rò torí ẹjọ́ tí èèyàn bá rò ni adájọ́ ó ṣèdájọ́ lé lórí ṣùgbọ́n mi ò sọ pé gbogbo adájọ́ ni áńgẹ́lì tàbí wòlíì torí pé ara wa ni wọ́n ti mú àwọn èèyàn àwọn ẹgbẹ́jọ́ tó wà ń kà náà lọ di adájọ́ bí òye olúkálukú bá ti rí ni ó ṣe ṣe ẹni tí ilé ẹjọ́ lè ṣe àtàwọn tó wà ní ìgbọ́nu àyìn adájọ́ ò ní pé ó yẹ ká máa mú ẹ̀kọ́ àti ẹni tó bá kún ojú òṣùwọ̀n ó yẹ ká jẹ́ kí yẹn máa kó jẹ́ ní tí ó jọba jù lọ́kàn wa láti fi hàn sí adájọ́ pé àwọ̀ ìwà ṣé ẹni tí ó lè máa ṣe bí ewé omi tán lè máa tìka báyìí sẹ́ni tán lè lọ gbówó fún tí ó dìdàkudà ni á ti wo gbogbo yẹn yàtọ̀ sí ètò ẹ̀kọ́ òfin tó ní àwọ̀ ìwà yẹn gbogbo yẹn láwọn àrò àní ro òṣèlú pé ọmọ ẹgbẹ́ olóṣèlú mi ni ó wúlò ládájọ́ kò wúlò ládájọ́ jẹ́ ká sọ dádájọ́ ìyẹn ò ní dà kò lè ràn wá lọ́wọ́ aráàlú náà kì í dẹ̀ ṣe pé tó bá sọ pé adájọ́ ṣe gbá adájọ́ ṣàwo àwọn aráàlú tó bá náà lọ fún wọn ní bribe ẹ bá àwọn èèyàn ló lọ fún wọn àwọn èèyàn tí bá ń fún wọn ní bribe káwọn náà mọ̀ lọ mọ̀ wọn à sì ní kò sí adájọ́ tó lórí láyà tí ó ránṣẹ́ sí ẹni tó ń ṣẹjọ́ nílé rẹ̀ pé ọya wà mú fún mi wọn ní ṣe àwọn aráàlú tá ń lọ fún wọn lówó àti àwọn náà ń kún wọn lọ́wọ́ kì í ṣe gbogbo adájọ́ ló burú kì í sì ṣe gbogbo adájọ́ láńgẹ́lì ibi gbèdéke ọ̀rọ̀ mi nìyẹn àwọn tí a bá rí i pé wọn àkójú òṣùwọ̀n tó yálà wọn lè dúró lórí ẹsẹ̀ wọn torí kò sí adájọ́ tí ó ṣàdájọ́ tí ó sọ pé àwọn èèyàn ò ní wá sọ pé kó ń bá wọn yí ìdájọ́ padà ní irú tí mò ń sọ 1997 bí ọ̀rọ̀ gbòyí náà ni wọ́n fi mí sí ìgbìmọ̀ kan lọ́sùn ìgbìmọ̀ ìdájọ́ nípa ètò ìbò ohun tí mo ṣe mọ̀ nìyẹn mo ti mọ̀ àti tọ̀sún àti tòsí tán wà ní kiri ìyẹn ni mo fi mọ̀ pé wọ́n á máa wá dájọ́ kiri nígbà tí mo wá ti mọ̀ bẹ́ẹ̀ yẹn àwọn mẹ́ta là ń ṣèdájọ́ wọ́n dẹ̀ sọ pé mi ni màá kọ̀ dájọ́ wọ́n láṣọ ọjọ́ kejì mo láṣọ ọjọ́ kejì àní kúrò ní kóòtù àwọn lọ́ọ̀yà á sọ pé kan lọ nǹkan ìwà tá à ń sọ pé stand down pé ẹ dúró á dẹ̀ padà 2 hours mo ti kọ̀ dájọ́ ibi tá a ti ṣe yẹn ẹni tó ń wà ní ìdí mi ìtí ó wá ṣẹlẹ̀ tọ́pọ̀lọpọ̀ ìfímọ̀ ni pé ìtọ́ fi máa pé gbogbo èèyàn tó bá ti lọ ṣèdájọ́ ẹ gbowó ó ṣe kínní kan ìtọ́ fi máa sọ bẹ́ẹ̀ nù torí àwọn aráàlú máa wá wọn kiri lóòótọ́ ṣùgbọ́n ẹni tó wá ń sá kiri tó ń wá mí kiri nígbà tí mo wá kàdájọ́ kò wá sí ní tó kàn ṣùgbọ́n torí pé kò yé ṣùgbọ́n torí pé ó ti wà lọ́kàn àwọn èèyàn wa pé tó o bá lọ fi owó àbẹ̀tẹ́lẹ̀ fún ẹni tí ó dájọ́ ò lè rí ìdájọ́ òdodo ìyẹn ní ká mú kúrò mẹ́ aráàlú tó ń ṣe yẹn ẹ má ṣe bẹ́ẹ̀ mọ́ torí adájọ́ ò ní ránṣẹ́ sí pé kẹ́ mú wá.
ẹ ṣe amòfin Awoniyi Alabi pé ẹ ti bá wa ṣàlàyé ọ̀rọ̀ náà yékéyéké ó sì ti yé ó yé àwa tí a béèrè lọ́wọ́ yín ó sì yé àwọn tí wọ́n wà nínú lọ́wọ́ yín Oluchi.
Thank you so much. Thank you for making it to the program. Thank you for actually explaining all these things to us, and I'm sure our viewers have also enjoyed this topic.
My pleasure.
Saturday morning treat. Yes, this is actually where we will also be join the curtain on the third guest platform on the SMT. The program continues shortly. Please stay tuned.
And for generations to come.